Thanks for joining us. Lewis, we should just double check to make sure we're all good, so just grab that. We're the requisite 1.5 metres apart. Sanitizer if we need it, okay? So we should be fine. Look, we've got a tremendous amount to cover today, and I appreciate that people have a very large number of questions. We've had hundreds and literally hundreds of questions by people who have already logged on. We won't get to them all today, but we're going to do our best, and we've got quite a bit of content. So it's great to see you, by the way.
Yes, good to see you.
It's been 4 weeks.
Well, I've seen you through Zoom and other social media apps, but not in person.
Not in person. That's good. You need a haircut, by the way. You need a haircut. But I'm sure we all will do the same. So, look, we'd like to talk a little bit about the operation of JobKeeper. We could probably spend 2 or 3 days talking about that, so we're going to try and do that as simply as we can. The main focus of today is the quite dramatic changes to the Fair Work Act that relate to people receiving the JobKeeper payment. We're then going to try and get through about 7, 8, 9, 10 common questions, and if we look at all the questions we've got, they sort of fall into baskets, and we'll try and deal with those. There's been quite dramatic changes to a number of modern awards, and you and I have been personally involved in spearheading that, so we'll talk a little bit about that. Talk about the unpaid self-isolation leave that came through last week.
Yes.
For 99 modern awards. And if we have time, we might not. We'll see if we can get through some questions.
And we do have the ability to take them, so feel free to ask them, and we'll hopefully get to some of them, and anything that's left over, we'll try and get back to you after the webcast is finished.
And if you can keep the question down to 1 or 2 lines, that'd be great, because some of the questions actually were quite lengthy last time we did this. So let's just start with JobKeeper. I think by now most people have read quite a lot about JobKeeper. It's essentially a government wage subsidy. It's a $1,500 payment per fortnight, applicable for eligible employers and eligible employees. And at this stage, the payment regime is running from 30 March 2020 for a period of 6 months through to 30 September 2020. Don't know if the government's going to contemplate extending it, but that probably seems to be the window where the greatest economic concern in the community probably is at the moment. There's a number of really important issues here. The first one is what is called the turnover trigger or turnover test. And essentially, businesses that have turnover of under $1 billion have to have a comparable impairment of 30% of revenue. I'll talk about that in a sec. Businesses with a turnover of over $1 billion have a much more stringent test. That's a 50% impairment test. A number of things to say about this straight away. In terms of what the tax office is looking at in terms of revenue, it's going to concentrate predominantly on your business activity statements, so your BAS returns. In terms of big businesses who operate in groups, the test to begin with for working out whether or not you're above or below $1 billion is what's called an aggregated test. That is, you need to take into consideration all of the businesses that are related in your group, connected or affiliated. Some of those tests can be quite complex Corporation Act tests. Ian Rennie, head of commercial law in our business, is very good at that, but it can be quite a difficult test. You apply that aggregated test to work out are you under $1 billion or over $1 billion. And once you've done that, that then says, well, for each individual company in that group, I'm either applying company by company the 30% test or company by company the 50% test. Charities are in a world of their own, which is very pleasing for people in charities operating today. Their test is 15%. And again, it's essentially an impairment test looking at this month, by way of example, could be April, compared to, say, last April. Could be a month-to-month comparison, can also be a quarter-to-quarter comparison. But you have to get over that threshold first. You've got to demonstrate that level of impairment, that level of shortfall in your business compared to a year ago to trigger getting into these subsidies. In terms of who's involved employee-wise, Lewis, do you want to just quickly take
it through? So a couple of matters that are required to be satisfied there. The employee needs to have been employed as at 1 March 2020, which generally aligns with when the significant social distancing and other public health order measures started to come into place. The JobKeeper payments apply to full-time employees, part-time employees, They do not apply to casuals unless the casuals have been with you for 12 months and have been working for you on a regular and systematic set of engagements for that 12-month period. So what we're talking about there is they don't necessarily need to have had full-time hours, but they need to have had a volume of hours or a pattern of engagements that is regular, that's systematic, and that's gone for a 12-month period before casuals can take advantage of the JobKeeper payments as well. There is, as you'll see on your slide there, a requirement for employees to be 16 years of age or older. That's going to be met by most of the workforce. And then the other requirement that's caused a lot of noise, and you may have heard a lot of questions about within your business, is what happens to people who aren't Australian citizens? What happens to people on sponsored visas or who are otherwise residents of overseas jurisdictions? The short position is this. Employees to access the JobKeeper payment, that is for their employer to be subsidised for that employee's wage, they must either be an Australian citizen, Australian permanent resident, or an Australian resident for tax purposes who is on what we call a subclass 444 visa, which is effectively a visa for New Zealand-based employees or New Zealand citizens. So all other sponsored workers, if they are not on that subclass 444 visa, they cannot qualify. So we're primarily talking about New Zealand citizens and residents only if they're not Australian citizens or permanent
And I'll just
residents.
quickly add on the casual issue, because we had quite a few questions come through before I went on casuals. There's no casual earnings threshold to qualify. There's no casual hours threshold to qualify. So if you've got a casual who's regularly and systematically worked, say, 6 hours a week for you for the last 12 months, they tick the box. They don't have to have been earning $750 or more per week. So that's the rule around casuals. I think that's as clear as we can make it. But here's the challenge, because a lot of our questions that we're getting this week are about, well, when does it start? When do I become eligible? And you've been doing a lot of work on that. So I might get you to go through that, because that's quite complex.
Yeah, so it might not have needed to have been as complex, Nigel, but it is that complex, and that's sometimes what happens when governments get involved in doing things. But if you qualify for JobKeeper, and broadly speaking, qualifying is what we just talked about on the earlier slide. That is the turnover test, and you have eligible employees that meet the requirements we've set out. If you qualify, that doesn't mean you're automatically entitled to the JobKeeper payments. Rather, that's
the first hurdle.
That's right. That's the first hurdle. And then there are a subsequent series of hurdles, just like in the traditional school athletics hurdles race. You clear the first, there's 5 more. Well, there actually are 5 more, and they're up on your screen. The first is your employee must have given to the ATO. Well, the employee gives it to you, and you pass it on, a nomination form which indicates that the employee wishes to nominate to form part of the JobKeeper scheme. So one of the things that some people might be intrigued by is what that means is you can only get JobKeeper payments with respect to employees who agree to be nominated. You actually require their consent. And not only do you need their consent, they need to fill out the form, and the form needs to be provided to the ATO. Now, that form was not available until yesterday. It's finally become available, but that form is now available to nominate your employees. So that's the first step. The second step is you need to notify the Commissioner in the approved form that you elect to participate in the JobKeeper scheme. Now, I think a huge number of employers have already registered their interest, but you can't actually formally enrol in the JobKeeper scheme until the 20th of April. So the second test can't actually be satisfied yet until 20 April when enrolments are available. The third test is one which is a periodic one that you're going to need to keep satisfying, and that is that you need to give information about the JobKeeper payments that are to be paid to the ATO, including details of the individual in an approved form on a periodic basis. And those are the details that will essentially determine the quantum of the payment. And that needs to be done as well. The fourth requirement is that the employee must have been paid at least $1,500 in wages, salaries, commissions, allowances in the fortnight which the JobKeeper payment relates to. Now, this is a critical element that's causing a lot of concern for employers. It's not only that you have to have paid them $1,500 for the fortnight, it's that you have to have paid them $1,500 in the fortnight. That is, they must have received those monies in the fortnight with respect to which you're seeking a JobKeeper subsidy. There are some exceptions for people who are paid monthly or on longer pay cycles than fortnightly, and there's a process whereby the Commission or the ATO Commissioner can reasonably reallocate the way the monies were paid. But if you're on a fortnightly pay cycle or weekly pay cycle, you actually need to ensure that the monies are being paid. What that means is, and we'll put aside the first 2 fortnights in April, is that you can't have an employee not being paid anything by you for a month or 2 months, subsequently decide to pay them retrospectively and then claim the monies. Doesn't work that way.
So it's the catch-22 that a lot of people rang up about this week, in that I don't have the cash flow to bring them back and pay them now. Can I bring them back now, not pay them, and then when I get the JobKeeper, can I then give it to them? The answer is no, you can't.
That's right. So at least once we hit May, it appears that you're going to have difficulties in accessing JobKeeper payments at taking that approach. The one carve-out relates to the first 2 fortnights in April, which is basically the month of April when you multiply out how many days are in 2 fortnights. I don't know why they couldn't have just said the month of April, but it's the first 2 fortnights, where the ATO can approve JobKeeper payments even where all of the above prerequisites haven't been satisfied. And I think that's broadly designed to address these types of issues we're talking about, which is, well, I've got these people, I do want to pay them $1,500, I haven't yet because I just made them redundant, or there may be some reason that they haven't been paid, and you're in the process of fixing that up. The ATO Commissioner can decide to nevertheless pay you JobKeeper payments for that type of employee. Now, that doesn't mean you will get paid, it's just there's a discretion on the ATO to do it. And so hopefully we'll see some more collective rulings coming out from the ATO about how they're going to exercise that. But I was going to say the short story, but it's somewhat of a longer story, is that all of these requirements need to be met before you're entitled to assent from the ATO. And the reason why that's really important is because Nigel's just chomping at the bit to talk to you about the Fair Work Act changes, and he's like a bull at a gate here. But unless he clears all these hurdles, you don't get in the front door.
You don't pass go.
That's right.
You don't collect $200.
That's right. So that's why it's really important to ensure that that you meet these requirements, and if you have concerns about them or doubts, then obviously you might want to get advice. Yeah,
and I'd probably say in terms of advice, if you think about what Lewis has just talked about, I think the best place to go to is your accountant, or if you're a large company, talk to the CFO. I think in relation to sort of the more complex things about, well, how does the aggregation principle work if we're a large group of companies, come and see people like us. We'll certainly help with that. But in relation to this sort of fine detail of lodging the forms and the like, I'd really be going and saying, go and talk to the accountant. Now, before we jump on, I am chomping at the bit to have a go, but before we go on, this question that's come up very quickly in the last 48 hours, and it's a question about one in, all in. And what that means is, if the employer applies for JobKeeper, is the employer required to offer to all of their employees who would otherwise be eligible to get the subsidy for them, or can the employer pick and choose which employees they invite to fill out the form? Now, the legislation on our reading of it says it really was meant to be all of them who are eligible. If you look at the ATO's website at the moment, that's a lot more vague. It's suggesting that it might be a discretionary consideration. I could, if you like, offer it to some of my employees and not others. Look, we don't have a definitive answer on that at the moment, but I suspect over the next 48, 72 hours that will get resolved as we get close to that kick-off date that Lewis talked about. But that is a question a lot of people are asking at the moment. Is it one in, all in, or can I pick and choose? Conflicting views at the moment, depending on whether or not you look at the law or you look at the ATO website. As soon as we get an answer on that, we'll let our clients know through our website, through an alert, as soon as we get an answer on it. But just be conscious about that issue as well. Now, if you, as Lewis said, if you get through all of those delightful hurdles, and I suspect the ATO will have some degree of administrative leniency in how that goes, you get access to a variety of flexibilities you didn't have before. And the most critical one is an ability to stand down in whole or in part an employee without pay, subject to the $750, $1,500 threshold that we talked about, and we'll come to that. You can also give them directions to do duties they wouldn't normally do. We'll talk about that. You can give them directions to work on different days of the week to the ones they normally work, or to work different hours. We'll talk about that. Those are the three directions. They're all overseen by a particular test called the unreasonableness test. We need to go through that for you. And then there's two other flexibilities that have been introduced for people who have the benefit of JobKeeper, and that is the ability to request and agree to a number of additional flexibilities, including the taking of paid annual leave, and help me out for the one I've forgotten at the moment, Lewis.
The taking paid annual leave and perhaps double leave and half pay?
Yes, that's one. We'll come back to it anyway. We'll come to that. We'll call that conversation a work in progress. As Lewis just said, if you aren't qualified for JobKeeper and you don't satisfy all of those requirements that Lewis just identified, you don't get the benefit of these things. So please be very sensitive about the fact that these are only for people who are qualified and for whom there is an entitlement arising from JobKeeper subsidy scheme. So the first one is stand down, and what does stand down essentially mean? It means in a set of circumstances, I can say to my employee, without terminating you, please go home, I don't have to pay you for a period of time. There are very specific stand-down provisions in the Fair Work Act. There are also many enterprise agreements that have stand-down provisions, and quite a few employment contracts have stand-down provisions as well. These new stand-down rules, which apply to the JobKeeper group, apply despite all of those things. So it might well be that you want to use these. It might also be that you decide that what you've got in your employment contract or enterprise agreement is more beneficial. So it's not that one kills the other, it's just that you've now got potentially a smorgasbord if you are a JobKeeper participant. And the stand-down provisions are very, very broad. Essentially, you can give a direction to an employee simply on the basis that you can't usefully employ them. There's no useful work for them to do. You can ask them to work fewer days. You could ask them to work less hours in days, or you can ultimately reduce their hours down to zero as part of these stand-down arrangements. And the big difference here is that normally there has to be a legal test of a stoppage of work outside your control. That test has been removed for these provisions, and you just simply have to say, can I usefully employ this person or can I not because of COVID-19? And that's really the test now.
And the other really big advantage out of this is this notion of a partial stand down.
Yeah.
That you can actually say, well, I don't really need you for some of your hours, but not all, and I'm going to give you half the hours
I'll have you Monday, Tuesday, but I don't need you Wednesday, Thursday, Friday.
That's right. And generally stand down under the Act traditionally operate on the basis that there's a stoppage, I don't need this person. Now we're at a different world, which is there's I don't need you as much as I once did. I'm going to reduce your hours as I see fit. And that's a significant addition to the flexibility afforded to the employer.
Now, we've put a lot of content up, and we normally don't do that, but the devil's sadly in the detail. And there's quite a few requirements before you actually decide to give this stand-down direction. The first one is you've got to be qualified for JobKeeper, and we talked about what qualified means, under the 30%, under the 50% threshold in terms of impairment. That big test is I cannot usefully employ the person for the period I want to stand them down, and we'll talk a bit more about that. Any direction you give them's got to be safe, and you'll see that's a consistent theme throughout this legislation when we talk about it. You've got to be entitled to one or more JobKeeper payments during the period of stand down, and that's that fortnight that you just talked about.
That's right. They're those 5 hurdles. They all need to be satisfied.
All be satisfied. And then you've got some guarantees you've got to meet. You've got to meet what's called the wage condition guarantee, the minimum payment guarantee, and the hourly payment guarantee. And so let's just quickly go through those. Cannot be usefully employed. Look, it's a reasonably settled test. In other words, do you have productive work for this person to do in the ordinary course of running your business? You're not required to manufacture work for somebody. And it really should be a test that could be easily determined on the facts of what they're doing.
Yeah, and there has to be a net benefit associated with the work. So you might have some work, but if there's no net benefit to the employer from doing the work, then generally the decisions say, well, that person can't usefully be employed.
So getting them to clean the office up really only can go so far.
That's right.
Yeah, it only goes so far. As we've already dealt with qualified for JobKeeper, we've already dealt with the entitled to one or more payments, which is the conversation Lewis went through. Lewis, do you want to just quickly run through the other three?
Yeah, so the other three, it's interesting the way it's set up. They all overlap and they kind of increase in terms of their breadth. The first point is you need to satisfy the wage condition. The wage condition, quite simply, is you need to pay the employee who's going to be subject to any of these directions $1,500 a fortnight. So they need to be getting $1,500 a fortnight. One of the things we didn't say earlier, but it's probably worth saying, is that is total gross payments made to the employee. It can include, that means that the tax that you withhold from the payment, but what it does not include is any superannuation that you might pay on top. So it's $1,500 a fortnight, but you can't count the super you're paying as part of the $1,500. So that's the first condition. The next condition is the same as the first with a little bit added on, and that is they must receive either $1,500 a fortnight, which we've already talked about, or the hour or the payment for the hours of work that they have performed. So if the hours of work are greater.
If I did enough work to earn $2,000, then the minimum payment guarantee is $2,000.
It jumps up to $2,000.
If I don't do enough work to earn the $1,500, the minimum payment guarantee is $1,500.
That exactly right.
It's the greater of.
Yes.
The greater of.
And then the final one is the hourly pay guarantee, which again, it's just a little bit of an addition to what we've already talked about. The hourly pay guarantee builds on the earlier concept and says you need to receive each hour the equivalent of the hourly rate you get under a salary or under an award, hourly rate of pay under an award. You need to ensure that for each hour they work, the employee gets the base rate of pay they would ordinarily get for an hour of work for that particular hour in that particular day. And the second thing is, if the employee is doing additional duties or more complex duties or higher duties, they must receive the hourly rate of pay that applies to that type of work under the relevant industrial instrument, whether it's an award or an enterprise agreement.
It's a bit like a mixed function concept. If I'm doing a role that involves high rate of pay, that's the rate of pay I get for those hours.
That's right.
Yeah.
Yes.
Okay. Well, I thought that was fairly clear. I thought that was fairly clear. Look, when doesn't that apply? Importantly, you can't, if you're standing somebody down, stand-downs don't apply for periods of authorised leave. They don't apply for periods of authorised unpaid leave or when you're otherwise absent. And Lou, one of the questions we got hit with a lot when we started talking about these new laws was, and I'll try and frame this question the right way because it was I'll try and do it simply because it was quite a complex question, but I think simply put it was something like this. Let's say I've got somebody working for me and they're in receipt of JobKeeper. They're getting their $1,500 a week, $1,500 a fortnight. Can I send them on annual leave, reduce my annual leave balance for them and still get the $1,500? And the answer is?
Well, the answer is you can still get access to JobKeeper if someone's on leave. Whether you can send them on annual leave is a different question, which we're going to come to later. But if someone is validly on annual leave, that is, you've met the requirements for taking leave or directing leave, the JobKeeper payments do not cease, or you are not disentitled to them merely because someone's on annual leave.
And of course, as we said, they've got to be lawfully sent on annual leave in the first place.
Yep.
Yeah. Now, there's an overarching obligation if you're going to give a stand-down direction to consult. The consultation is truncated. It's a 3-day consultation period. The employee has to be given a written notice of the intention to be given that stand-down direction. You've got to have at least 3 days before giving the intention and then actually issuing the direction. And consultation, as we've said on many occasions in the past, it has to be something that's not just perfunctory. It's not, hey Lou, in 3 days' time I'm standing you down. It's really a genuine opportunity to talk about the pros and cons of what might happen to you in the context of that stand down, which we'll come to later on when we talk about unreasonableness. So please, it's a genuine consultation period and there's got to be a 3-day gap between written notice of intention, and then the giving of the direction. Now, I'll just say it now, this consultation process doesn't just apply to the stand-down direction, it applies to the other two directions as well. So when we go through those, just remember they involve the consultation obligation as well. Now, the next obligation, that's stand-down.
Yes.
And I suspect that's the one most people will be looking at to try and moderate hours back to the JobKeeper payment in some fashion. The other direction you can give once you are JobKeeper in the JobKeeper world is you can actually give a direction to an employee to do duties they normally wouldn't do. And look, my sense of this is that this is a refinement concept. It stops people getting into that argument of, oh, look, that's not my classified role under the award, or that's not my job. And it's really about sort of everybody sort of doing whatever they can to sort of keep things going. And again, some very simple parts of this direction. You'll see again, you've got to be qualified for JobKeeper. You'll see again, you've got to be entitled to one or more JobKeeper payments during the period. All of that's very standard. What's different here is it's got to be within the employee's competence and skill. So I can't ask somebody to do something they're simply not competent to do. It's got to be safe. If they require a licence or specific qualification to actually perform the work, they've got to hold it. And you've got this nice little test which says the duty's got to be reasonably within the scope of the employer's business. I'll be interested to see how that's applied. I used the analogy yesterday talking to a client. Well, if you're a candlestick manufacturer, you can't ask them to start cleaning down stables. It's got to be within the broad scope of what you're actually doing. But if you satisfy those hurdles and subject to one test, which we will come to because there's multiple tests, you can actually direct somebody, to perform duties different to the duties they perform today. So that's the second direction. The third direction, which is probably a pretty common sense direction, is the ability to direct an employee to work somewhere other than where they normally work. The obvious choice at the moment is working from home, which we've been doing now for quite a while. And again, you'll see very similar requirements again, qualified for JobKeeper, entitled to one or more JobKeeper payments during the period, safe, standard requirements in terms of these directions. Then you get two very particular requirements. The place is suitable for the employee's duties. Now, I think that'll be a fairly stretched concept. I don't think suitability really will come down to the fact that my wife's at home with me and she doesn't like me working at home. She's getting tired of it after 4 weeks, I can assure you. I can assure you of that. Yours is probably more tolerant than mine, I don't know. But, you know, you certainly wouldn't be, I think, reasonable to have an employee take sort of heavy machinery home and try and do something at home in that environment. And the other one is that the duties are at a place that's reasonably within the scope of the employer's business again. So we're kind of back to that, what is the general scope of the employer's business? So that's stand-down direction. That's direction to do different duties. That's direction to work somewhere different, which could be the home or could be another work location. And those are the basic requirements for those. And those last two have a very particular test though. So this doesn't apply to stand down. It applies to doing different duties and working in different places. And this is a curly one in a way, I think.
Yeah, the test has a lot of different facets to it, as you'll see on the slide, lots of bits bolded there. You can only issue the direction if the employer has information before them that leads them to reasonably believe that the direction's necessary to maintain the employment of the employee. So there's three facets to that. The first is you need to have some information before you. So it can't be...
Something factual.
Yeah, which I don't think gut feel qualifies for. You actually need to have some type of factual information that has given you the basis to form a belief. And that belief needs to be reasonable. There's lots of case law on what reasonable does and doesn't mean, and we don't need to go into that in a great deal of detail. But what's really interesting is that you need to reasonably believe that it's necessary to give the direction to maintain the employment of the employee. And that's really, you start to get into these notions of a but-for test. That is, but for issuing this direction, the employee probably will no longer be able to be employed.
Be redundant.
That's right. And so what you'd be looking for is, well, there's no other way the work can be performed. which means if I don't give this direction, I'll have to let the employee go, or there's no other way we can do this and maintain the financial viability of the business. If I don't do this direction, the business might have to shut down. And those are the types of kind of scenarios you would need to roll through and effectively speculate as to what would happen if you didn't issue the direction. And what you need to get to is a point where you form a reasonable satisfaction based on the information before you that if you do not do it, the employment will effectively need to cease.
And I must say, you've got to read these alongside the public health orders that the state governments and territory governments are issuing in terms of social distancing, in terms of not being allowed to go into your workplace unless it's essential, actually a prohibition in terms of how those public health orders work. So if you think for most people, I tend to think of this as the working from home direction.
Yep.
Because at the moment, public health orders say, well, you can't go into the office if you're able to work somewhere else. Well, this is the other side of that equation, just making it ultimately clear the employer can say in those circumstances, well, I'm going to get you to work from home. I think most people have voluntarily done that. We've actually had some people who've been pretty unhappy doing it, but this gives you that clear opportunity to direct them to work from home, but subject to meeting this test. And I think in that context, while you've got that very stringent public health order, you're probably going to meet this test fairly easily. If that public health order came off, that might be a different issue.
Yeah, and you'd need to start forming a view based on those tests.
Those tests. So 3 directions you can give once you're in the JobKeeper world. The big one's probably stand down. You've got these other 2 directions which relate to duties and place of work. The duties and place of work direction has this test. Stand down doesn't have this test. All 3 require consultation. And then there's another test. There's another test. And all 3 of them have this kind of fail-safe test as well, just in case. And that is that any of these directions, any of these 3 directions, cannot be unreasonable in all the circumstances. So if an employee took exception to one of these directions and they could demonstrate that it was unreasonable in all the circumstances, then the direction wouldn't actually be able to stand. Now, this is pretty broad stuff. Now, without getting too legalistic, something that's reasonable or less reasonable, slightly not reasonable, is not necessarily unreasonable. Unreasonable is a pretty high bar, but all the circumstances means just that. So this would involve a consideration of the specific circumstances of the employee to find out whether or not in their situation you've actually triggered unreasonableness. And as we said to a client, I think 2 days ago, we talked about the fact that they had an employee whose husband had lost their job, they had 4 children, they had a problem with the mortgage, and then we were talking about whether or not in their circumstance, partially standing them down would be unreasonable in all the circumstances. In their circumstances, it was getting kind of close. So just understand that this test sits over the top of those 3 directions, and it's a pretty general test. I think what this does is it forces you to realise that consultation is important, and you should be just challenging yourself that you haven't been so relaxed in the consultation that you failed to pick something up that might put you in trouble with this test.
Yeah, and just to follow on from Nigel's comment, I mean, lawyers do have a field day in the difference between, what's reasonable versus what's unreasonable. But I think at the end of the day, it doesn't matter if someone would have done something differently. It doesn't matter that there's multiple ways to do things.
It's not about preference.
And you choose option A over option C. What matters is when considered as a whole, was in all of the context, can you say, well, there's no way that anyone could reasonably do that, or is it quite clear it's unreasonable? So it doesn't mean that you have to choose the particular path that a different person might choose, but it still always cannot be unreasonable. So I think what's really interesting is what Nigel raised about the circumstances of a particular individual that might have particular hardship considerations. The only way you can properly assess the reasonableness of that direction is to actually look at the impact on the business itself. Because again, if you start to get to a point where, well, if I don't stand them down, I'm probably going to have to exercise my right to make them redundant, because I just can't keep them on.
Or if I'm a very small business, that actually could be the difference between me operating or not operating.
Then all of a sudden it may be reasonable.
Yeah,
Again, it'll depend on every particular individual incident.
I think what's really important is that you can't just generalise in terms of giving these sorts of directions, because if you do generalise, you might find yourself getting in trouble. Let's crack on, shall we?
Yes.
Now we've got a couple of. This is the one I forgot earlier. Sorry, I forgot. You can
different days.
You can request somebody to work at different days and different times, and if you do make that request, then the employee is required to not unreasonably refuse to agree to do that. And I might just do this one, so I'm sort of on. Basically, employer says, this is what I want you to do. Employee considers it, can't unreasonably refuse the request, and again, we're back into this reasonable debate. Then most of what you see on the screen is very consistent with what you've seen before. Qualified for JobKeeper, safe, reasonably within the scope of the employer's business, entitled to one or more JobKeeper payments during the period. So you're starting to see now fairly consistent sort of language in terms of the tests that apply. Now, the big kicker here is, and I'll get you with this one, okay? We'll see how we go. So let's say I ask the employee to work on a Sunday. They normally work, say, on a Thursday. On a Sunday, do I still pay them ordinary time? What do I pay them, Lewis?
So, good question. Look, when you look at these provisions, what they create is a right to ask the employee to work a different day, and in most circumstances, they're going to have to, unless they can get a reasonable refusal up. What this provision does not do is it does not change the award provisions for that day. It does not change any penalty rates for that day. So if on that day you have an award obligation to pay a particular penalty rate, then that penalty rate will be applicable, because there's nothing in these particular provisions that says that the award rate is overridden. So you will need to ensure you're complying with that hourly rate of pay that's specified in your underlying industrial instrument.
And what we're seeing at the moment is this seems to be a big issue around part-time employment, and people sort of getting ready for saying, well, look, I've sort of balanced my workforce out a little bit. David normally works Monday, Tuesday. What I'd really like to do is get an agreement with David to move to Monday, Thursday, because I've got other people filling in now at different times. So I think this will probably work out quite well. I'm not sure too many people are dramatically going to be asking people to work Sunday, but we'll wait and see. And of course, this might apply to people who aren't covered by awards as well.
Yes.
And in that sense, there might actually be, for a salaried employee, a request to work on a weekend. You're going to chide me now, because I've been making you work every weekend for the last 4 weeks, so you'll go, what difference does it make? But that's a possibility as well. So again, importantly, that's by request and agreement.
Yes.
Which is different to the direction rules. And accordingly, the unreasonableness test doesn't apply to this. The must be necessary to maintain employment doesn't apply to this. And the consultation doesn't apply to this as well. And there's one more request and agreement. Bear with me. No, we haven't got it up on the screen. There's one more request and agreement, and that's the one to take annual leave.
Yeah.
This is your field, so I'm going to let you...
So it is on the screen.
Is it? Oh, there we go. Here we go.
Because you needed some annual leave, Nigel. Our
problem is that title's wrong.
Oh, yeah.
We have a quality problem.
So you must, you can request an employee to take annual leave, and they have to comply with that request, again, unless they have a reasonable basis to refuse. So that is, the employee cannot unreasonably refuse the request. Again, you need to qualify for the JobKeeper scheme. There's a couple of additional obligations which are quite interesting here. One, the employee needs to maintain a balance of annual leave of no fewer than 2 weeks' leave. And two, there is also an alternate ability to have people take double leave on half pay. Now, there's some interesting things here about this particular direction because, or request, I should say.
Request and agreement.
Yeah, request and agreement. Because you might find, depending on your industry, that it is easier or better for you to issue a direction under your award provision that currently exists.
Or enterprise agreement.
Or enterprise agreement. Or if you have an employee who is award or enterprise agreement free there is only one requirement that applies to any direction to take annual leave, and that is it's reasonable in the circumstances. You might find that some of the existing Fair Work Act framework that exists is actually a little bit easier to navigate than this particular request and agreement provision, primarily because this requires the employee to retain a balance of 2 weeks' leave. You don't have that necessarily in all of the awards. You don't have that in all EAs, and you don't have that if you're award or agreement free. So you might actually, if you do have a desire to run down your annual leave balances to assist the company during this time, you might think about which type of mechanisms you use under the Act, because maybe there's other mechanisms that fit you better than this one. If this one works fine, then you can use this one too.
And I think that's a really good point in the sense of these JobKeeper flexibilities, as we said earlier with stand down, they're in addition to other things you might be able to access. They don't kill those other options. So it's really a case of, well, look, if I'm able to get JobKeeper and I can access these flexibilities, are these the ones I want to use, or are some of the others better? And so that's a very important decision to make, rather than just simply saying, well, now I'm in the JobKeeper world, I have to use these ones if I want to use them. You don't. So that's an important question to get through. Now, of course, the question we got asked, I think we got a lot of people asking us this on Monday in preparation. What happens if the employee disagrees, or what happens if I've got a unionised workforce and the union says, well, hang on, you've triggered the unreasonableness in all the circumstances or whatever? And the simple fact is that the Fair Work Commission has a very broad supervisory power in relation to any dispute about any of these matters. Justice Ross, the President of the Fair Work Commission, is currently setting up a particular part of the Commission to deal with disputes that come through. My understanding at this stage is that they're going to run those disputes pretty quickly. What we would have called, when I was younger, rough justice. Probably deal with it on the day, ex-tempore decisions, that is, decisions off the cuff, no detailed formal evidentiary process. We're here now, you've got to give some evidence, get in the witness box and get on. So it's going to be a fairly rough and ready process to try and fix these disputes as they come up, because I think the Commission realises they need to be resolved fast for the benefit of both the employer and the employee. The Commission's got very broad powers in dealing with these disputes. It can reinforce a direction that's been given. It could set aside a direction. It can substitute a direction. And it can make any other order it considers appropriate, and that is as long as a piece of string. And at the end of the day, it's really looking at fairness between the parties. So just be mindful that if there's any challenge to how you're exercising these direction powers, Fair Work Commission can get involved and it can sort it out very quickly, and it can give a binding decision, and it will. Yep. I suspect it'll ask the parties to try and solve it first, but it can give a binding decision. Some common questions, if we can, Lou. Must an employee follow a JobKeeper direction? The answer is yes.
Yep.
It's actually strange. It's probably the first time ever I think we've seen in industrial legislation in Australia where you're legally compelled to follow a direction. It's a bit unusual in Australian laws. Normally it's all about what the employer does or doesn't do. But yeah, you've got to follow a direction. The employee has to follow it. It's legally required to follow a direction. Does the JobKeeper direction need to be in a specific form? It's got to be in writing. Now, we're waiting. It might end up being in an actual template form, but we haven't seen it yet.
There's no forms issued yet. There's a possibility to prescribe some forms for some of the directions, but nothing's been prescribed to date. So at the moment, it's just in writing.
Yeah. If an employee is working under a JobKeeper direction, what happens to their continuity of service? All carries on.
Yep.
So whatever the rules of continuity were before, they all carry on. What happens to accrual rules? Same as before.
Yeah, so the accruals for an employee continue to accrue, notwithstanding that the JobKeeper direction was given. So if you've reduced someone's hours, or if you have stood someone down, the fact that those things have happened or you've changed their days or whatever it might be does not affect their accrual. They continue to accrue as if they worked the hours that they had before the direction was given.
So if I was a full-timer before I'm accruing a full-time rate, even if I've been stood down to 1 day a week, I'm still accruing my annual leave, etc., at my pre-stand-down rate.
That's right.
Yeah, it's very important to understand that. Question we get all the time, must the employee at least receive the full amount of the JobKeeper payment?
Absolutely.
Absolutely.
Which, just for the sake of absolute clarity, means if someone is earning $300 a week or $600 a fortnight from you because they don't do many hours, if you want to access JobKeeper, you have to pay them $1,500 a fortnight.
Yeah.
So for some people working small numbers of hours, they will actually see a windfall gain. You must pay them that amount to be able to claim any subsidy back from the government. There's no ability to claim lower amounts than $1,500. You can only claim a $1,500 payment because you've paid the employee $1,500 in the period.
Yeah, and probably the question we get asked quite a bit, I think we got this yesterday from quite a few people, was, let's say I have a casual who normally earns $300 a week. Can I ask them to do more shifts to take them up to the $750? Well, there's nothing to stop you asking them to do that. These laws don't give you the right to compel it, so it'd just be the normal rules would apply in terms of offering that casual more shifts in the normal sense that they can accept or decline in the normal course of the way they normally work before this. There's no right for an employer to compel an employee to work enough hours to earn the $750 if historically they haven't. Just be very conscious of that. If I stand an employee down in whole or part, can they get a second job to make up the difference? Now, we won't go into this, we don't have time, but there's some very specific laws around this. Part of the JobKeeper legislation package means that the employee is legally entitled under certain circumstances to go and get that second job or third job. There is a conflict of interest test. It's a little different to a standard conflict test in the sense that it would have to be a very obvious and demonstrable conflict to stop that person going. And they also have a right to request training and professional development, and there's a very particular part of the Act dealing with that. Again, probably give us a call rather than go into that today, but those two things can be done. And the big question everybody says is, well, where does redundancy fit in?
Well, it doesn't. So if you're issuing a JobKeeper direction, one of the benefits of these things, particularly if you're standing someone down, well, you're doing something that's lawful and contemplated by the Act and authorised by the Act. It does not give rise to a redundancy. And so if an employer does not wish to make an employee redundant, they do not need to do so. Of course, you still can if that's something you wish to do for your business, but a stand down under these provisions would not be a redundancy, which gives quite a degree of assurance to employers because these provisions are likely to operate till 30 September.
Yeah.
Now, if you stood someone down under Section 524 of the Fair Work Act, there's going to be a question about how long you can stand someone down under those provisions because they're not meant to be indefinite. And at some point, an employee might say, I believe I'm redundant because they've been stood down for too long and too indefinitely under the usual Fair Work Act provisions. That can't arise here for any stand downs that go to 30 September because they're all authorised by the JobKeeper amendments.
I suspect for small employers that's probably not so important, but for the bigger ones, particularly unionised employers, that actually could become a real issue because we've already seen a lot of unions contest the legitimacy of some stand downs and also debate, well, how long's that stand down going to go? Because normally in the past couple of months or thereabouts is the accepted duration of a traditional stand down under, say, the Fair Work Act. So that's really important to understand that. These are much more beneficial stand down provisions and they do not, under any circumstances during that window, trigger a redundancy or redundancy payment. Well, look, that's JobKeeper, and I know it was rushed, and I'm sorry, but there actually is quite a bit to get through. And I think I've just gone through my list. We've kind of answered, as we've gone through, about 15 or 16 of the questions, which were kind of the majority of questions. But let's just spend the last 10 minutes, if we can, Lou, just going through the awards.
Yep.
Now, you might have to move a little faster through this because we've only got 10 minutes left. But off we go. Now, we should set this up. Justice Ross, President of the Fair Work Commission, convened major parties about 3 or 4 weeks ago now. To their credit, Australian Council of Trade Unions was very cooperative 4 weeks ago in that process. We were privileged to be a part of that acting for the Australian Chamber. Lewis and I did that in person. Other employer groups were involved, and we've managed to secure quite a few flexibilities in a number of key awards at the moment. That well of goodwill appears to be drying up with the union movement at the moment a little bit. We don't know. We'll wait and see. But we're still looking carefully at pursuing a number of changes in a number of awards. But these are the ones we've done to date.
Yes. So there's three there's three categories of changes or three different awards that are affected thus far in terms of the ones that the parties have moved themselves. So the Hospitality Award, the Restaurant Award, and the Clerks Private Sector Award are the three awards where employer organisations effectively come together with the union movement and by consent sought variations. We've got hospitality up there on the screen at the moment. A couple of key changes. One, which I'll just mention now and won't mention again with the other awards, is this ability to direct the performance of work in any classification, provided safe and licensed to do so. Now, you've already heard Nigel talk about that in the JobKeeper sphere. One of the things that still remains, as is the case in the JobKeeper sphere, is that if you direct someone to do work of a higher nature, or more complex, or a higher classification, higher duties, allowances and things like that will still apply. My two cents worth of commentary on this is I suspect employers were all doing this anyway. I don't think you really need it in the award in these quite extraordinary times to get someone to give you permission to do this. I think it's one of the first practical things employers would look to do, but it's nice to have.
Well, no, most employees that I've experienced say, what do I need to do to help?
Precisely. Yeah. So I think it's there. It's in all three awards. Probably not much more needs to be said about it. In this award, which we'll see in the Restaurant Award as well, there's quite a flexible ability to unilaterally reduce the hours of a full-time or part-time employee by up to 40%. So that is, you can reduce their hours down to 90%, 80%, 70%, or even 60% of what they were working before, subject to some pretty clear consultation obligations that have been inserted, but you'd expect to have to consult because what you're talking about is quite significant and dramatic power. Now, we don't have time, as much as I'd like to, and again, we talk about lawyers having a field day, to actually discuss the contractual availability of this. There is a really intriguing question. If the award gives you this right, does that then get around any contractual commitment you have to employees to offer them a certain number of hours? My personal view is, given the way that these award provisions are worded, they may well override any contractual entitlements. It's not been tested. You'd want a comprehensive advice on your personal circumstances if you're worried about contract clauses. But that's the right that's been put in the award. The next provision that I won't go into a lot of detail about is this point about accrual again. Service-based entitlements will continue to accrue as if the hours hadn't been reduced. And then you have an ability to direct the taking of leave on 24 hours notice. And this is a great example where the award flexibilities we've achieved...
Better than JobKeeper.
Exactly.
Yeah.
And so that's why you might want to look in your industry, do I actually have something better in the award? So that's the Hospitality Award. We move to Restaurant and you'll see a lot of similarities. You've got the same reduction in hours, don't need to go into that again. Same with accruals. You've got that ability to direct leave on 24 hours notice. There is one extra change, and that is there is an ability to close down part or all of the operations until the expiration of the award schedule for the purposes of providing annual leave to employees, and when they run out of annual leave, unpaid leave.
Unpaid leave.
This is effectively a quasi-stand-down clause because what it does is, provided you're closing down the operation to allow people to take leave, you effectively can then have them run out their annual leave and move on to unpaid leave. It's, again, an area where you might find your award provision might be more flexible than the JobKeeper provisions. There's no test about being usefully engaged, there's no test about reasonableness, and there's no test about maintaining people's employment, etc. It's a much more streamlined provision. And if you're in this industry, it may be that you might want to choose to use the award provision. And part of the reason that these award provisions have been possible is because when you look at the industries we're talking about, the industries that have been decimated. And accordingly, that's why the unions accepted there was a need to be able to do things to at least maintain employment, even if it is while the business is shut down.
And clerks, just quickly, very, very similar approach in clerks, but also a variety of benefits to direct working from home.
Yeah, so working from home, the big win here in the Clerks Award that we probably need to look at in other industries is that if employees are working from home by agreement, there was an acceptance by the parties that with all the things that are going on with school children being home at the moment as well, employees may not want to necessarily work 9 to 5. They might be homeschooling at that time. They might be chasing a child around the backyard. And with that...
I think Lewis has just described the world he's in.
Yeah, well, I'm not homeschooling. I'm chasing a child. But if that's the world you're living in, you might find it easy to work early in the morning and late at night. But the problem is the span of hours might make those hours overtime. And so the changes that we got in the Clerks Award allow those hours between 6 a.m. and 11 p.m. to be treated
ordinary time.
As ordinary time, provided the employee agrees. And that's a big gain where you have workers actually working from home and wanting to choose their own hours.
And then on top of that, we had 99 modern awards changed last week. Commission acted of its own motion. It's a very particular variation to those 99 awards. It's provided for that double annual leave at half pay. And again, that seems to be just about everywhere at the moment, be it a JobKeeper proposition or in here. But very importantly, it's provided for unpaid leave of 2 weeks duration in circumstances effectively where the employee is required to self-isolate. This is other than being sick. If you're sick, you obviously take personal leave. Or through government requirement, you're prevented from attending work. Good example recently would have been that hospital in Tasmania when through government health order, they actually said the hospital has to shut, even though all of you might not actually have been exposed to COVID-19. It's a very particular form of leave. It's unpaid. It sits separately to award and National Employment Standards benefits. And I'm going to say it's importantly, it's one grant of 2 weeks leave. This hasn't been tested yet. Commission, though, in its decision made it very clear this wasn't a per occasion benefit. The presumption being that hopefully if you did have to self-isolate, you'll only have to self-isolate once.
Yep.
I haven't got the list of 99 awards. The ones that are excluded are construction, maritime, mining, but the majority of awards I think most people are probably looking into who are viewers today, they've all been covered. Doesn't impact enterprise agreements. And I think if you look at those changes, you probably quickly sum up and say this. If you are part of the JobKeeper world, you've got access to some pretty decent flexibilities. If you're not part of the JobKeeper world, you've got access to these modern award flexibilities, plus whatever was already in the Act, already in your employment contracts or your enterprise agreements anyway. And also, if you are in that JobKeeper world, you can pick and choose. It's a smorgasbord, and you might decide that the JobKeeper stuff's better, or you might decide what's in your enterprise agreement's better. So really, the last 2 or 3 weeks have been about trying to work to create a different array of flexibilities to help employers and employees get
Now, we promised we'd answer some questions.
We've got 1 minute. We've got 1 minute. Got 1 minute.
First question, and this is coming up a lot. We have Lisa said, how do you satisfy the $1,500 payment per employee for the first 2 weeks of April if you're unable to register until 20 April and you're not able to pay back the difference? That's an excellent question. And the answer is, this is a real issue with the way that the JobKeeper payments have been set up. It is dependent on you paying employees in the fortnight. So for the first month of April, the ATO may take a lenient approach. So I would still seek to have JobKeeper for those months on the basis you will pay. But once we hit 1 May, you need to be paying in the fortnight. And if you consider you're unable to do that, or you have any concern about your eligibility to claim JobKeeper, you're going to have to do a risk assessment as to whether it's worthwhile paying or not, because you might not get the money back.
And I suspect some people will say, don't have the cash flow, don't want to take the risk. I'll bring those people back in 2 weeks' time, which is a bit sad. It really is a bit sad.
That's right.
But understandable, entirely understandable.
I've got 2 others I think we can quickly
I think we
knock
can
off.
run over. I'm not being told we can't. Yep, let's run over.
We've got Erin that asks, And the reason I picked this is because I think it grapples with something we haven't looked at really at the moment. What happens in what Erin describes as a high-risk employee who's not working from home, they've been given a laptop, able to work from home, but refusing to complete tasks. So we've got two issues there. We've got they're not following a direction, which we might come to because there is an ability to grant these directions about places of work. But also you've got this question about disciplinary action during this whole world. And I think that's something employers need to start turning their mind to is normal rules aren't suspended, but I think you do need to take a more practical and empathetic approach to what's going on at the moment. The fact that people are probably more distressed, the fact that communication is more difficult. And so the disciplinary processes that ordinarily apply are not suspended, but equally you should probably be thinking about taking a more measured and constrained approach to what's
Yeah, and
happening.
I'd probably say, it's interesting to say it that way, because I'd probably say it a slightly different way, but the same thing. What's a lawful and reasonable direction in our office might be slightly tempered in your house.
Yeah.
So you just need to be conscious about, particularly with things like deadlines.
Yeah.
So we've become quite flexible. Well, let's just, can I have it sometime today? Whereas historically we might have said, well, I want it by 3 o'clock. And the answer is, well, you know, they've got 4 children. So I think it's, you might need to be a little bit more flexible, but normal rules apply. And somebody's refusing to do something, they need to be dealt with. Yeah.
So I think we've received a number of other questions. We will come back to you on those other ones after the webcast. Thank you for having me, Nigel.
It was good to have you. And as always, if you want to drop us a line, info, I-N-F-O, @ablawyers.com.au. We'll do our very best to get back to you. Mate, I don't know when do we see each other again? Is it going to be? I'm going to put a bet. We'll be back in the office in 3 weeks.
I will publicly say it's probably more like 3 months. So we'll see.
Okay. Well, I'm hoping I'm right.
As am I.
As are you, I suspect, in 3 months' time. But look, thanks for joining us today. And look, stay safe. I appreciate that for a lot of business owners right now, these are extraordinarily troubling times. And as I always say to my team, look, our best will be good enough. And I wish you well. If you need any help, please give us a call and we'll do what we can to give you the assistance you need. Take care and please stay safe. And thank you very much for tuning in today.